Washington Advisory Committee to the U.S. Commission on Civil Rights shall come to order. I'd like to acknowledge that regardless of where we are zooming from today, we are on the land of the first people. The land I am living on is the land of the Coast Salish, the land which touches the shared waters of all tribes and bands within the Squamish, Tulalip, and Muckleshoot nations. Here in Seattle, we are on the traditional lands of the first people of Seattle, the Duwamish people, and we honor with gratitude the land itself and the Duwamish tribe, past and present. This acknowledgement does not take place of an authentic relationship with Indigenous communities, but serves as a first step in honoring the land that we are all living on. For the benefit of the public who have joined us today, I will introduce my colleagues and myself. My name is Alexis Harris. For identification purposes only, I'm a professor of sociology at the University of Washington. Members of the committee who are present here today are Kimberly Ambrose, David DeWolf, Andrew Kaufman, Zan Nider, Brian Screener, and I don't think I missed anyone else who's present today on the committee. And other members of our committee are Tony Benengas, Luzamina Carpenter, Judith Endigan, Gary Laughlin, Conrad Reynoldson, John Sarafili, Eric Schnapper, and Aaron With, which I'm sure many other members will hop on when they're able to. We have a quorum present, and yes?
Alexa, if this is Brian, and if you'd allow me to just say some words, I think it's important to acknowledge the sad tragedy that happened in Atlanta last night, and the just horrific violence that the Asian American community and our Asian Americans and friends from abroad are suffering and feeling these last couple months. So I just wanted to share those thoughts and share my empathy and sympathy with the Asian American community and all Asians around the world.
Thank you. Thank you, Brian. You were coming in and out a little bit, and I actually was. I'll build off of what you just said in a moment. I do think it is important to acknowledge what's happening in our country. Also present are commission staff: Brooke Perry, civil rights analyst, Angelica Trevino, support specialist, and Kelly McGrath, a civil rights intern. And we really want to give them a special thank you to all of the work they've been putting into organizing these hearings for us. The U.S. Commission on Civil Rights is an independent bipartisan agency of the federal government charged with studying discrimination or denial of equal protection of the laws because of race, color, religion, sex, age, disability, or national origin, or in the administration of justice. In each of the 50 states and the District of Columbia, an advisory committee on the commission has been established, and they are made up of responsible persons who serve without compensation to advise the commission on relevant information concerning our respective states. Today, our purpose is to hear testimony regarding Washington state labor laws and legal practices that potentially prevent full transparency and accountability for any disproportionate use of force. Today's meeting will also include a period for public comment later on in the agenda, and we will have an opportunity for members of the public to share their perspectives and opinions. If you are a member of the public and have joined online, commission staff will be messaging you to see if you would like to comment. Please keep an eye on your chat box for that moment. For the members of the public who are joined on the phone with audio only, you will be able to indicate with your keypad when we reach that point in the agenda if you'd like to make a comment. At the outset, I want to remind everyone present of our ground rules. This is a public meeting open to the media and the general public. I want to remind everyone that this meeting will be transcribed from a recording for the public record. I ask that you please state your name when speaking. Panelists should limit their initial remarks to around 10 minutes. After all the panelists have spoken, advisory committee members will have the opportunity to ask questions. In addition, written statements may be submitted to Brooke Perry at bpery@usccr.gov by April 19th, 2021. Though some of the statements made today might be controversial, we want to ensure that all invited guests feel welcomed and do not defame or degrade any person or any organization. As the acting chair of today's meeting, I reserve the privilege to cut short any statements that do defame, degrade, or do not pertain to the issue at hand. Any person or any organization that feels defamed or degraded by statements made in these proceedings should contact our staff during the meeting so that we can provide a chance for public response. Alternately, such persons or organizations can file written statements for inclusion in the proceedings. I urge all persons making presentations to be judicious in their statements. The advisory committee appreciates the willingness of all participants to share their views and experiences to this committee. And I really appreciate Brian's opening statement, that I also want to acknowledge the horrible moment of violence that our country experienced last night. We mentioned on Monday's hearing that many of us were acknowledging the 1-year anniversary or mark of the killing of George Floyd and Breonna Taylor, and the killings last night are the same type of violence and trigger the same types of emotions and frustrations. And I really hope that and thank those panelists today and the committee members and the public for showing up, because these types of hearings, these conversations that we're having are helping to prevent violence in our country. So we can use that energy and that fear and that frustration and the sadness to try and do at least something good today. So thank you for being here. I would now like to begin our meeting by introducing today's panelists. We are joined by Mr. Merrick Bobb from the Seattle, who is a Seattle Police Monitor, Mr. Brian Beggs from the Spokane City Council President, Ms. Monique Harrell with Equal Rights Washington, and Senator Jesse Solomon, who is a Washington State Senator. And I'll note that he does need to leave early, so if you see him jump off, it's because he has very important work to do for all of us today. So with that, we will begin with Senator Jesse Solomon, and then after, and I will be keeping time. You each have 10 minutes to speak. I'll be timing it, and with the 1 minute mark left, I'll just let you know that you have 1 minute left to go. So we'll begin with Senator Solomon, and you have the Zoom or the whatever we're on, the WebEx is yours.
Great, thank you. Can you hear me okay? Can you hear me?
Yes, we can hear you.
Good. Okay, well, I plan to focus mainly on a arbitration reform bill that I introduced and helped draft and write. And then if time allows, I can talk about some other police reform bills that are moving. Does that sound okay?
Yes, yes, thank you.
Great. So responding to some of the outcry, of course, around George Floyd and specifically some of the editorials from the New York Times and the Seattle Times about the need for changing the police arbitration process. I'm assuming that people are kind of up to date on what that is. And showing that about 50% of the discipline that's been imposed by police chiefs or sheriff tends to be lessened or overturned, and having terminations based on excessive force overturned and officers being reinstated to the force. I felt like we needed to do something. I thought it was odd that this particular profession had the ability to hire, after discipline was imposed, pay for a private lawyer, or in part pay for a private lawyer to sit in judgment of the discipline that was imposed by the employer, and give this private attorney the authority to overturn it. I would love to have that, but I just don't think as an employee that I would deserve that. So the bill we drafted, and I was working closely with the ACLU, it changes what can be bargained for. So right now, a lot of police unions bargain for wages, hours, working conditions, all the traditional standard stuff. And my bill, absolutely, want to be clear, doesn't touch that. Don't have a problem with that. Go ahead and do that. But unusually, I think police unions also get to bargain for police accountability and disciplinary procedures. And so one thing this bill does is it changes and eliminates a whole host of things that fall under the police accountability system, including you can no longer, under this bill, require a waiting period before a law enforcement officer is interviewed after a shooting or something of that, something like that. You can't preclude the investigation or imposition of discipline based on a sort of artificial time limit. So in Seattle, there's 180 days to get it done, or they can't move forward as an employer. And I think that's kind of an artificial limit. Collective bargaining can't limit retention, disclosure, or review of body camera and in-car footage by the employer. Can't limit secondary employment management oversight. So a lot of police have sort of moonlighting jobs as getting hired for overtime via private companies, and they also have their own sort of internal security companies that get the business and then they dole it out to their fellow employees, and that's a separate system from the employer management. And so it creates this weird imbalance that makes it hard for a police chief to change the culture, because it creates this other sort of center of gravity. Can't limit the authority or composition of civilian oversight entities through collective bargaining, limit public access to disciplinary decisions, require specific standards of review that are greater than a preponderance of evidence, prohibit law enforcement officers employed from releasing misconduct information to other law enforcement agencies that may be hiring this new other officer, obtaining information from prior employees about misconduct, and allowing that or requiring that discipline be consistent with past practice. So something that happens a lot is you go to arbitration, and the arbitrator may believe that, well, times have changed and this more severe discipline around sexual harassment makes sense, but we have to go with past practice. And if past practice was more lenient, then we have to make the discipline that was imposed now equally lenient, and that we need to get away from. Other aspects of the bill eliminates private arbitration. So it takes that out entirely. It does still allow for disputes to be heard by a hearing examiner or a administrative law judge or a civil service commission, but it takes out that private hire issue, which I think is sort of inherently a conflict of interest. Appeals would still be allowed, but only for well-defined dominant public policy established in law. So it's pretty limited, the basis of which you can appeal a ruling from the administrative law judge or hearing examiner. And the standard, the default would be to uphold the discipline. So the hearing examiner would uphold the discipline unless there's a finding that the discipline was imposed in an arbitrary, capricious way or based on an illegal reason. And the hearings would be open to the public. There's also a mandatory discharge section, which it's probably not the core of the bill, but certain things like theft and excessive force, which we're working on defining in another bill, violations of that would be a mandatory discharge. We also have a great decertification bill that's moving through the House right now that deals with that. So unfortunately, what happened is, well, we did get a hearing on the bill, which was awesome, but we had some opposition from labor from the get-go. And essentially, there's a coalition of folks who've lost family members via police shootings that are largely by agreement setting the agenda for what we do this year in the legislature. And I want to be clear, we have an amazing, unprecedented number of impactful, hard-hitting bills that they're supporting. But members of the labor community participated in that coalition and helped guide the agenda-setting process. And I think with the objective intent of excluding the type of reform that I'm putting through. And, I was even told by members of labor who were on that committee that we had an agreement, that there's an agreement to only go after the coalition priorities. And I said, well, I'm not part of that agreement. I'm an independently elected senator, and I'm going to go forward with it. We did get a hearing, which was kind of the most we realistically expected. And I thought it was a really good hearing, but we couldn't get the bill out of committee. It went to Labor and Commerce. So there's some labor support for it, but a lot of the public unions are afraid that we are interfering with collective bargaining rights, and that's sort of a holy system to them, a sacred system, and they're having trouble with that. So here we are. The bill's not going to pass this year, but there is another year, and unfortunately, the issue is not going to go away no matter what we do. If we pass all these other bills, such as no-knock warrants, chokehold restraints, no chokeholds, things like that, and we don't have a good enforcement mechanism, if and when an officer does violate those provisions willfully, then we're kind of, to some extent, back at square one. We're going to likely see more protests, more incidents, and then that'll shine a spotlight on this particular problem. So it's fine to pass these other bills and move them along, and I think we need to do that. And then I think this issue will remain, and we'll have to figure out a way to go forward with it. But it's, to be clear, a very tough battle. Whether I think Republicans are in control or Democrats are in control of the legislature, it's hard. I think that was my 10 minutes.
Thank you so much. Yeah, you were under 10 minutes, but I was so interested in what you're saying, I forgot to watch the stop clock. So thank you for that. We appreciate that. Next, we have Mr. Mayor Klabb. You're on mute.
How about now? Is that good?
Perfect.
Yeah.
Yes, we can hear you. Thank you.
Good. Well, thank you all very much for allowing me the opportunity to address this panel and this topic. I was introduced as the monitor in Seattle, and certainly that was accurate and was perfectly appropriate, at least until August 31 of this last year, when I stepped down and a new monitor was selected by Judge Robart for the process. So I am no longer the monitor, although I am obviously following it with great care and also am pretty well up on the issues. Certainly up on the issues that were just discussed by Senator Solomon. And certainly as a wholly personal matter, am very supportive of his bill and what it is trying to accomplish. I think that one of the things that's most important is that the various communities that are served by the police departments have confidence, have faith, and can rely without problems on the various police departments that they operate with. And one of the things that the community wants is that there be fair, open, transparent, and equal-handed discipline given out. That the process for evaluating an officer's conduct be a public process and be something that all of us outside the police department can and should know about. Therefore, these should be public hearings. We also agree that the system as it exists today at least has the potential of being unfair in that it can be weighted either in favor of the police officer and against discipline of any particular police officer because of a series of rules that, as the senator described, apply to those kinds of situations that don't apply to other kinds of situations where you're looking to whether discipline should be imposed. And so as the senator went line by line, basically, through the provisions of the various of the bills, you can see how each of those that he mentioned has the potential of weighting the bill or weighting the discipline to be imposed to make it less likely the discipline will be imposed and more likely that it will not. One of the things that I found most frustrating during the time that I acted as monitor was that the decision of the chief of police, and that is a considered opinion by the chief of police. That's not a top of the head kind of decision. Those matters are worked up very carefully through the Office of Professional Accountability or through the chain of command. And they come to the chief of police with a full and complete record. One of the things that I did as monitor was to review those records to make sure that what the chief saw included everything that bore upon the problem and presented them in a fair and honest way that left those sworn officers, be they a lieutenant, a captain, a commander, or the chief of police, in a position to have a full, complete, and thorough record so that the officer against whom discipline was imposed was interviewed at an appropriate time under appropriate circumstances, was not allowed to have opportunities to have his or her story massaged by the labor representative or others, was not allowed too great a period of time between the incident and the interview so that others might have an opportunity to change the person's recollection or try to change the person's recollection. All of those things go to a decision by the chief of police that is usually fairly well made. Those are not snap decisions. Those are based upon a record such as you would have from a trial or appellate proceeding. Therefore, one of the things that I would respectfully suggest is that the chief's determination have some kind of presumption of correctness, such that an arbitrator would have a pretty heavy burden to justify turning aside what the chief has decided and imposing his or her own judgment. And so I would recommend that if there is a private arbitration uh, uh, possible that the senator includes some kind of presumption in favor of what the department has determined. I saw too many cases where individuals who had done very bad things and whom the chief had decided to terminate were put back into the department by an arbitrator. And I thought some of those decisions were quite infuriating, as did the federal judge in at least one of those cases. I think we have to look at each of the proposals that the senator has made or that the ACLU has made and ask whether they tend to support a full, fair, and thorough hearing or tend to make it difficult and frustrating to get discipline. And I think that because of Washington's odd system, where so much management prerogative has somehow slipped and become bargainable, is a situation where the balance needs to be restored. I don't know whether I've gone 10 minutes. It feels like I have. So with that, let me send it back to you.
Thank you so much. You were perfect with the timing and really helpful in talking about these stages in the process to get to accountability. The next person we have is Ms. Monique Harrell.
Thank you so much. So I'm just going to give an overview. My name's Monique Harrell. I am the board chair of Equal Rights Washington, she, her pronouns. And I have had an opportunity, I've had an opportunity to actually take over much of Monitor Bob's work. I now serve as the deputy mayor or the deputy monitor for the Seattle police consent decree. And I approached this from a community perspective, and much of what Senator Solomon and former deputy, former monitor Bob have said are very much true, and I just want to highlight a few of those things. But start with a little bit of background. In general, what labor does is very important. The ability to collectively bargain to create safe workspaces and to create environments in which all employees are treated with respect and fairly is very important. However, police unions have fallen very far behind when it comes to issues like racial equity and advances that have been made in the overall labor movement to be more inclusive. And I say that just to set the stage, because we cannot legislate values in that way. It is very difficult to legislate values. So we work to legislate outcomes. We set laws and rules to try to legislate outcomes. But a lot of it has to do with where are we in this moment, and not what is just protecting ours versus theirs, but really needing our police labor unions to be able to come along on this journey with us as we work to become an actual better nation, where we are moving, where many of our labor partners are moving us forward on issues of racial equity and really trying to train out of their members bias that we've grown up with. Anybody who's grown up on this land at all has grown up surrounded by a certain amount of bias that we have to unlearn if we are truly going to be, if we're going to lean into the future that we know this country is capable of. So now I'll talk a little bit about what it is in labor law, particularly in law enforcement labor law, that harms those outcomes that we seek to legislate. There are a lot of attempts to obscure or hide records that officers may have, misconduct that may come forward during their course of serving. We have a lot of professions that have very high responsibility to humans, and so we require a certain amount of transparency from them, even though they are still supported and represented by labor. And I'm specifically thinking of like nurses unions and others similar. Our medical practitioners are held to a high standard because they also in their hands hold the abilities to influence human life. Our law enforcement officers have the ability to take life and liberty from those that they serve, and so there should be a higher standard. And I think that that's really important. Law enforcement labor unions have fought to obscure disciplinary records to protect what they consider their highest priority, which is that officers' current and future employability. And what I will argue there is the right to hold that job over that of life and liberty of the communities they serve is not the highest right. We do want people to be able to support themselves, to be gainfully employed and do all of those things. However, it is not your right to have a very specific job. I think it's a privilege to be able to serve the public, and not everybody is fit for every single job. We know people who in every single profession that are not good fits for that profession. There may be people who just don't have a good bedside manner if they're a doctor. There may be professors who just cannot nurture young minds. There may be police officers who just can't set aside their personal bias or cannot de-escalate a situation, and we have to admit they're not a fit for the job. Labor unions should not be protecting those where it is a greater danger to our community for people serving in that roles than saying, candidly, this isn't the role for you. When we see victims of law enforcement violence, the first thing we usually see about them is the incident, and the second thing we see about them is why they deserved it. And when we talk about labor, the first thing that we'll hear from labor is that officer's record of misconduct is not valid to this incident. And I'll argue it is, because if there is a history or a pattern of excessive use of force, of bias, of any of those things, if you can put the victim on trial, you certainly can make the circumstances that led to that in terms of the violence perpetrated on them. That also should be a part of the public record. And to me, that's just a part of having symmetric information. It is that asymmetric information that actually allows the injustices to continue. And it's what police labor unions rely on. They work to continue to obscure certain pieces of information from their department, from future departments, and from the public in order to continue to move without responsibility. And that's the part that has to stop. So to speak to a few things, and Senator Solomon did a really good job of overviewing some of the efforts outlined in his bill. We have double jeopardy when it comes to cases because we don't want to unfairly be able to bias the system and just keep going after people. In the way that the arbitration system is set up, there's like a double jeopardy on the other side. You have to not only prove your case once, but you have to prove it another time. Okay, let's say that that's fair to make sure that we're getting the process right. The part that shouldn't be embedded in that is the ability to enter new information, to get an entire preview of the case that's coming before you, and then say, great, now I've seen how that team practices, and now I'm going to bring my full A game. It is essentially like getting one side getting an opportunity to fully see the case against them, and then being able to present their own case now that they know what they're going to do. This happens all the time. And this is why a lot of arbitration gets overturned, or a lot of these get overturned in arbitration. It's because of the allowance of introducing new information, right? It's because of holding that spade in your pocket, not being transparent from the beginning, and saying, you know what, I'm gonna seek that out, and I'm gonna put that in at the second bite of the apple that I know I'm gonna get. If it is truly a fair system, it should be a review of all of the facts that's made available the first time. You shouldn't get to hide a spade and then play it later in the second round. See, well, how well did we do the first time? I think we can do better. Here's some new information. All of that information should be made and should be forthcoming in the very beginning, in that first case. The one other thing that Senator Solomon touched on that I want to highlight is body cameras. Law enforcement labor unions have fought against body cameras for a very long time. And then they've said, if you want body cameras, if you want transparency, you're going to have to pay for it. And not every police department has the ability to pay the cost that the labor unions will want to ensure that there's constitutional policing. We shouldn't have to pay for accountability. We shouldn't have to pay for transparency. When you sign up for the job to be a law enforcement officer, that should be an expectation.
You just have a few seconds left.
Okay,
sorry.
Great. No, that's perfect. And so I want to just be able to say that labor should absolutely be able to bargain for safe environments, for fair wages, for all of those things. They should not be able to bargain for accountability and transparency. Those things should be the floor for holding the job, and not something that you aspire to once you get the job. So thank you so much, and I appreciate being able to be here today.
Thank you so much. That was really helpful. And then our last panelist is Mr. Brian Beggs.
Yeah, thanks a lot for the chance to speak with you today. I'm Brian Beggs. I'm currently the City Council President in Spokane. I've been on the council 5 years. I am a civil rights lawyer by history and continue to have a small practice. And I have been litigating these issues since 1990. And I totally agree with everything that's been said about the broken disciplinary system for individual officers and individual events. But I wanted to talk about something else that we've been working on in Spokane, which is really more addressed at the policies and training for officers that have also had huge obstacles from our public labor laws. So back in 2006, a man with some cognitive impairments was beaten to death by Spokane police, and it just happened to be captured on video, not even really good video, but shoplifting cameras in a small store. He had done nothing wrong, but something went very wrong, and they killed him. His name was Otto Zem, and it became a very big case in Spokane. The police chief and the mayor totally backed the police, said they had done nothing wrong. But eventually the federal government prosecuted, and the officer went to prison. The mayor got kicked out, the chief got kicked out, the city attorney, all that. And we made a big change, and we actually, instead of a consent decree, went to the Department of Justice on their COPS voluntary program and made a lot of changes, a lot of good changes, but still have a lot of work to do. But one of the things that I realized, I was running a nonprofit at the time and a community activist on these issues. When I looked at all the people who had died at police hands over 6 years, almost 40 people, almost all of them had some type of cognitive impairment, either a permanent one or a temporary one from behavioral health or substance abuse. And we realized that it wasn't so much that there were bad officers, they just had really bad policies and training. And they essentially were operating in the world of, if someone doesn't immediately cooperate, use overwhelming force. And that was based on a system before they emptied the mental hospitals, essentially, in my judgment. But people whose brains aren't working correctly, using overwhelming force has exactly the opposite effect. And so we realized that our problems were really more policy and training. And so we came up with a different strategy. We came up with a civilian ombud strategy, where the ombuds wouldn't have the ability to impose discipline on anyone or really significantly impact it, but they would have the ability to observe and question and write a report at the end of it that would give transparency on what policies needed to change and what actually happened factually. And we thought that sort of continuous improvement cycle would be more effective than going after individual officers, which frankly, we just gave up on. We said, yeah, we're not going to get anywhere with that. I'm super excited, these bills that are coming now that have a new vision that we can get actual discipline when officers depart from policy. But what we ran into was that labor law was precluding even this non-disciplinary process. And, you know, even though I'm a lawyer and not actually an employment lawyer, I knew nothing about labor law in Washington. But what we found out was that labor law had some really old paradigms about civilian oversight and civilian input and quality improvement cycles. They didn't really recognize it. And they just immediately said it's a daily working condition, therefore you have to bargain for it, and you can't make us do it absent some huge arbitration case. And that wasn't, you know, that wasn't just police union arguing that. That was our own lawyers arguing that. And one of the things I realized is that our police chiefs don't really like oversight. Our risk managers don't like it. Our mayors don't like it. So even though the city council wants it because the community wants it, it's really hard to get. We actually ran a ballot measure to change our charter, to put it into our constitution of our city. It won by 70%. And it's still, we just now, after years and years of negotiating and debating, passed a police contract that has real meaningful civilian oversight just in the last few weeks. So that's how hard it was for the second largest city in Spokane to do that with crystal clear, solid community support. One of the other reasons it's really hard to do, even if you got a sympathetic mayor on your side on it, is that these issues are combined with financial issues at arbitration. So it's very high stakes. You know, the difference between a 1% raise per year in a police department of our size is millions and millions of dollars of a year. And so whenever we would say, well, let's go to arbitrate, let's fight this out at the PERC board, because there's some good PERC decisions in our favor coming out of Seattle on it. But our risk management people are like, oh no, we can't afford it because they will tie our compensation to it and we can never do it. So again, we started in 2007 to try to have this. We got something in place in 2008. We passed a city charter in 2013, and we just now got mostly what we wanted. So it is difficult, and labor laws need to be changed. And what I want, and we have a bill right now, Senator Billig, Majority Leader, has a bill that would take civilian ombuds type models out of collective bargaining and simply say, no, that's not part of collective bargaining. It doesn't impact discipline. And we've gotten some traction with some labor unions to say, no, police unions are different. Ombuds is different. But it's not a guarantee that it's going to pass, even though he's the most powerful senator and happens to be from downtown Spokane. So we're doing that. But to switch to just a few other issues, there are some amazing legislative bills this session and really put together by a coalition of legislators of color and other progressive legislators lending their support and voice, but really letting legislators of color lead It's been super exciting. And just to mention one, Jesse, Representative Johnson has a bill 1054 on tactics that would limit chokeholds and was going to limit police dog intentional bites that went off to the side, and several other kinds of things. There was a bill 1202 that didn't make it out of the House, but it's going to come back next year by a retired Court of Appeals Judge Mary Kay Becker. And it was awesome because it essentially creates a state law equivalent of federal Section 1983, except no qualified immunity. It actually got union support because they made it clear that if the violation of someone's civil rights was due to policy and training, the officer was not liable financially. It was the city that would be liable. And so that's going to come back. I'm really excited about that. There's currently right now a bill 1310, which is a de-escalation bill. It's one of the ones I'm most excited about. It really, it puts into law what real de-escalation is. As most of you know, de-escalation is creating time and space and communication that will help calm the situation down. Many law enforcement people argue that de-escalation is really overwhelming force, that when you send a dog on someone, that will de-escalate, or you choke them into unconsciousness, you've de-escalated because you didn't have to shoot them. And that really needs to get changed. And that bill, again, is going to have some tough sledding, but it's really good. I also really love Senator Solomon's bill on arbitration with the ACLU. And again, that's going to come back. My main takeaway, if I was going to get to the end of it, if I could leave you with something, underneath all of this is this very basic conflict between the community and its police. And the community under our law should really set the values that we want and the policies and the training that we want and the disciplinary standards. We should be able to set that, and it should reflect our will. And so as our community gets better educated and moves forward and understands racial bias and systemic bias, we can make those changes. But instead, in our community in Spokane, and I'm sure many others, there's this, Jack Nicholson, a few good men approach that police will tell us what the policy should be, what the training should be. They will tell us, and we should be grateful that they will do that for us. And that is really the struggle underneath all of this, is what kind of public safety do we want? What kind of peace officers do we want? And so I really do that. And the last thing I just wanted to say in my last few seconds is, we did a really interesting study, our police did, of having each officer, when they made a voluntary stop, punch into their phone the code of the race they thought the person was. And it showed a huge bias against African American and Native American people. And it was very helpful because those were calls that they were making, not responding to 911 or warrant calls. And so now we're moving on that. And then the last thing I just wanted to let you know that we have in our ombuds office is we have a use of force dashboard where we have an outside vendor analyze every use of force report and put a dashboard. So we have it by officer. And even in one case, we have it by a family of officers who commit a lot of force. Anyway, I'll leave it there. Thanks so much.
Thank you very much. Thank you to all of our panelists for providing all of this really important insight and information. We will now open the discussion to the committee members present to ask questions of our panelists. We have until 11:40 for this, so all of our committee members, please be mindful of the time. I will address each committee member in roll call style so that each member will have the opportunity to ask one question and one follow-up. And I'll begin with the end of the alphabet this time, so we can go the other way this time. Please wait for your name to be called before asking a question. If time allows, additional questions may be permitted. In the event that there is time for additional questions, please use the raise your hand function to indicate that you would like to speak, and I'll call on you to address the panelists. So let's begin with Brian Screener. Do you have a question for the panelists? Oh, Brian had to jump off to another meeting. He told me he'll pop back on. So Eric, we'll go to you, Eric Schnapper.
Thank you. My question, first of all, thanks to all of you for the work you've done in dealing with these very difficult and intractable issues. I have a particular question for Mr. Solomon. He's still here, yes. I would be the subject of your bill and the committee hearing referred to, I think, is very much at the core of what we're concerned with. And I'd like to ask if you could provide the committee with the documents that you've accumulated in connection with that. If there's a transcript of that hearing, I think it would be very helpful to see it. You've got statements of opposition or support. I think that would really enlighten us. I guess a question I'd like to ask is, in light of what you've heard from the public employee unions, do you think there's a way to frame this issue or a proposal that the public employee unions would not be opposed to? That seems to be a central problem here.
Sorry, I need a few minutes to stop laughing bitterly. So first of all, an apology. I realized the error of my ways when I was a UW law student and failed to take courses from you. And I regret that to this day.
Let's forgive
it. That laugh was a rueful laugh, R-U-E-F-U-L-L, rueful. Absolutely, I can get you the link. So all of our hearings, because of our great focus on transparency in Washington State, are recorded and immediately available on TVW. This was a Senate Labor and Commerce hearing early in session a couple months ago. I have the link. I'm just not sure how to get it to you, but we'll work on that in a few minutes. Your other question was, is there a way to frame this legislation or draft it to get labor support? And I don't see how to do that. But many minds on a bill can be useful, right? To maybe figure out a way to do that. But it goes to the core of some of the fears of public unions about having their collective bargaining rights changed or messed with through the legislative process. They say, I said, look, me, like I have 100% lifetime voting record with labor. Like it's not, you know what my agenda is and where it ends. And they said, well, but what if a Republican from another state that, points to this bill and tries to get them? I don't think that's relevant. Like they're going to do what they're going to do. They're not going to rely on what happens in Washington State to do it, right? If they have the power to limit bargaining, they're going to do it. So I don't really agree with that argument, but we tried to skinny down the bill and we just went with section 3 to get it out of committee, which was the limitations on collective bargaining, because the stakeholders and I, so ACLU and the sort of reform community in Seattle, Judge Livingston, Tim Burgess, etc., felt like limiting the subjects of bargaining was the most important thing. So that seems to kind of strike at the heart of the conflict, right? It's not easy to see our way towards a broad agreement. But I'm not the one with the best skills on that. That's not my forte. Sometimes I'm driving the aggressive change, but other legislators can and will help me if there is a path forward. And so
Thank you for that. We'll move to the next question. Conrad Reynoldson, do you have a question for our panelists?
Yes, thank you. And first off, I just wanted to thank our panel for taking the time out of their busy schedules to speak today on these important issues. So I think also my questions would be for Senator Solomon. I guess if you could talk, and I know we're kind of early with things, but what the prospects of the bill passing are really looking like, and then what are other opportunities for coalition building that we see with groups that might not yet be involved?
So thank you for that question. The bill did not move past committee, and we have cut off, right? So even though we're still in the legislative session, there's deadlines, right? So a bill has to come out of committee by a certain date. Did not do that. So it's not passing this year.
Sure, and I was mostly referring to in the future.
Yeah. So unfortunately, I think something else has to break in a bad way before I think my party, I don't rely on the other party, but before my party wakes up to this issue and says we're going to have to tackle this. Something in this country, in my opinion, broke with George Floyd, broke with the last administration, and there's a huge and real cost to that. Although I think there's opportunity for change right now because of it. But I fear there are tensions in the country, and I fear that they can go down a path that is destabilizing and violent and dangerous for us. But I just think we're not there yet in terms of passing the bill until something else horrible happens. Absolutely, coalition building is essential and helpful. So I think it was odd to me that the Martin Luther King County Labor Council kicked out the police guild, but then there was still not a lot of support from them for this bill. Like it sort of ended there, which I don't know. I have my own thoughts on it, but so any kind of building labor support is probably the most important aspect of this because they're most affected by the bill, and that would open up minds to move it forward. But any other voice is good. Like I think that's kind of a simple answer. Like the more people that say, "Hey, we need to focus on this," the more difficult it becomes for example, for leadership to say, "Oh, let's just do something else," which is it's a very easy thing to do unless there's a lot of pressure. There's a lot of bills, a lot of things we're working on, a lot of good things we're working on. So it's easy to take that hard stuff and just like, oh, some other time. That's all it takes to kill it.
Thank you for that. Zan Nider, do you have a question for the panelists?
Yes, and thank you everybody for being here today and taking time out of your busy schedules. We really appreciate it. I wonder if any of you can speak to how police union arbitrators, if they're held to any professional standards, how they're recruited and trained, and what levels of accountability exist for people in those positions.
Do you want to address it to certain panelists, or?
It's kind of open to anybody. I don't know who's working most closely with arbitrators.
I'm guessing Monisha or Merrick would be the ones.
Yeah.
Monisha, do you want to take it?
I'll start, and then Mr. Bob, if you want to jump in. So there have actually been efforts, actually even in this cycle, as part of another arbitration effort to limit, to actually have a vetted list of arbiters and limit an agreed upon arbitration list from a state level. And we have gotten a lot of pushback from labor on the limited list. The labor unions tend to look for arbiters that tend to be friendlier towards their cause and that they know have records of providing arbitrations that work in their favor. And so it creates a system where they are selected more often when they are working, when they are leaning towards the labor union's behalf in terms of keeping more officers away from discipline. There are efforts to create a system in which the list is a little more vetted, But again, those movements are going rather slowly because other labor unions are really concerned about kind of the slippery slope argument of once it starts occurring in police labor unions, then they're going to do it for all of our labor functions. So there's an attempt to address it, but the progress is a little slow.
Mr. Bob? There you go.
Okay. And does the picture say just a small picture? Okay. And then I was wondering whether the picture could come up and be full screen like the other pictures have been. But
Oh, I'm not sure how to adjust your screen.
okay. In any event, we have tried from time to time to think about ways in which to make the selection of an arbitrator less disposed to be just simply the labor people's desire for an arbitrator. One of the things that I thought about is why does an arbitrator have to be geographically from the county or the part of the county or the jurisdiction of the police department? And would you get a fairer group if you had them selected by somebody else and then appointed to arbitrate in a particular group? So say that you had a particular group that could pick 10 arbitrators that you could have in any one instance. They've all been vetted. They've all been seen to be fair. They've all seemed to be able to find on both sides of issues, and just have a rule that you have to take one of those 10 arbitrators and use that person, him or her, for your arbitration.
That
Doesn't have to
definitely
be
makes
the same state or not.
Thank you for that. That makes sense. Andrew Kaufman, do you have a question for our panelists?
Yes, I do. Thank you to all the panelists for your time and your comments today. I think my question is for Ms. Harrell. It has to do with the arbitrator. I'm wondering if you could sort of characterize what you think is the appropriate relationship between the police departments and arbitrators. Um, Obviously, you know, that's a concern of the committee and a need for reform is the role of the arbitrator. But I'm wondering, what are the circumstances where arbitrators ought to have more autonomy or ought to be able to substitute their own judgment for police departments? I'm just wondering if you could sort of generalize about that relationship.
So when you have labor unions that prefer a set of arbitrators, they begin to develop a relationship and they begin to develop a bias. And I think that it's really important that arbitrators, their role is to be neutral, right? And so I think when they begin to be requested, like proactively requested by labor unions, it means because they think that they're going to get, as opposed to taking kind of who's next up in line, it means they think they're going to get a more favorable outcome from a certain set of arbitrators. And when you are paid based on how often you're selected, it does provide an incentive in that regard. That is one of the reasons why legislation, you know, there was some legislation moving forth this year and it didn't get past committee. Ironically, on the same link that Senator Solomon included, there was another bill addressing collective bargaining and arbitration right before that bill. So that entire session is a really good one to watch because the whole topic is based on it. But I think that there should be a system where arbitrators should get timeouts, right? So many cases, and then there's a timeout to ensure that there's not an incentive to just continue making rulings in one direction. If you knew that you had, 10 cases that you were going to get over a certain time period, and then you were kind of like done or on hiatus or moving to another labor area practice, it encourages you to say, it's not the difference of how I rule is going to be one case, 5 cases, 10 cases, or 100 cases. It's I'm going to get 10 cases, so I should give my best judgment on those. I think that there are ways that we can deconstruct some of the potential bias, but we really have to be willing to work on that, and we really have to trust that if we provide incentives for people to want to be unbiased, that arbitrators will indeed do that.
Alexis, you're muted.
We
Yeah,
can't hear you yet.
It looks like you're unmuted, but we're not able to hear you right now.
I think the chair is asking Judy if she has a question.
Yeah, Judy, go ahead.
Okay. Hi there. I guess I don't know why I'm echoing, but
I'm receiving quite a bit of feedback from Judy. Is everybody else?
Yes, because she's on twice, maybe with another device.
okay, let me try it again. Okay.
It looks like Judy needs to unmute the one connection she has.
There we go.
Still lots of feedback.
I'm sorry, but here's a simple question. Has any jurisdiction anywhere gotten a better plan by legislation or otherwise that we could look to deal with the issue of holding police unions accountable and at the same time avoiding the conflict with the collective bargaining agreements? Is there anywhere in the country we could look to?
I can address that a little bit and then maybe turn it over to some of our other panelists. I think one of the things being done this year that will help is setting a floor on a statewide level when it comes to reviewing misconduct or histories, patterns of misconduct. And that's being done currently through a bill, Senate Bill 5051, which is a bill that would create pathways to decertification for officers with histories of misconduct. The reason it doesn't directly address the labor issues, but what it does is it says an officer's history is no longer going to be able to just be obscured by the department that they're working for at the time, and that they won't be able to basically, like, they know discipline is coming. And this happens quite a bit. They know discipline is coming within their current department, and so they quickly transfer to another department, where then, because they've left as an employee of the one department, basically the investigation ends because they're no longer a current employee. And so Senate Bill 5051 basically says you can leave that department, but the investigation into your potential history of misconduct will continue at the statewide level. And it's doing so in many ways as a workaround to the fact that discipline has often been stopped at the more local level. The minute an officer sees that it might be coming, and they can end it by just resigning or jumping to another department, right? So then you get another completely clean slate. And if you think about, we have almost 200 police departments in Washington state, right? So it's very easy to potentially have misconduct investigation that's going on in Seattle, and then just go, well, shoot, I might lose that one. So you drive 17 miles north, and then now you're a police officer in Shoreline with a clean record. These are some of the issues that we're trying to solve, because when you have a state that's got nearly 200 police agencies, there is a lot of opportunity to have that record just completely expunged and move on. We wouldn't expect that as citizens. If we, let's say we got into a car crash in Renton, we couldn't, just, pack up and move to an apartment in Seattle, and then all of a sudden your car crash in Renton is no longer valid, right? We still hold you responsible. And so I think this is one of those cases where, because labor hasn't risen to the moment of meeting discipline, the state is beginning to find other ways to address it.
Thank you. Can you hear me? A thumbs up. Oh, thank you. Thank you for that, Monisha. David.
Can I jump in?
Sure, please.
I want to talk about the decertification bill, and also there's an Oregon bill. To the first question, is there a model that's passed that we can work off of? I think the answer is no. I asked my staff to look at that, and they said no state has passed anything like we're trying to do with the police arbitration bill 5134. Oregon did pass something, and what it says is that you have to create a grid of discipline. So this act or behavior will lead to imposition of this kind of discipline, right? But that is done via collective bargaining. So I don't think, I think that's, I guess you could say, a big loophole. As to 5051, I just posted the link to that. It's a really important bill. It does much more than what Monisha said. It gives a state oversight, or it beefs up what's currently fairly, I think, weak state level oversight for, I think it's the Criminal Justice Commission to pull the card, so to speak, pull the peace officer license of any officer who runs afoul of certain things. So there's a mandatory decertification section and a permissive decertification section. So mandatory might be, commit felony, some sort of egregious excessive force, and then you have to look at the bill, but there's a whole list on both. But it also changes the procedure under which that is done. So under current law, you have to wait till all the procedures at the local level are exhausted, all the appeals are finished, which can take years. This bill allows decertification to happen with its own independent investigation at that state level board, which can be activated any time. So it can work a lot more quickly. I think that's the core of the bill. There's other aspects of it. I keep saying I'm sort of bitterly disappointed that my bill doesn't pass, but we're on track to do a lot on this in this space, and the decert bill, in my opinion, is probably the number one.
Thank you for that. follow-up. David, do you have a question for our panelists?
Yes, this question is for all the panelists. In your experience, once a disciplinary procedure has been initiated following an allegation of excessive force, is the process or the outcome affected either by the race of the police officer or by the race of the person or persons against whom the force was used? And if you believe that, could you provide some examples or indicate the magnitude of the problem? Thank you.
How about I'll call on the panelists. So, Mr. Beggs, do you want to begin to address the question?
Sure. I would say my experience in Spokane is that the race of either party is not a big factor in the disciplinary process, but Spokane, just to be clear, has very few police officers of color and actually doesn't have that large of a population of people of color. It's changing. There's a lot of young people who are people of color in Spokane, so that will change. So I don't think the investigation, the number one thing in the investigation to me is one person in the investigation is a commissioned officer, and then the person making the complaint is not. And essentially the entire structure is set up to believe the officer and discount any allegations unless literally you have it on video. And even if you have it on video, that is not enough. This is one of the reasons why I'm discouraged about using the existing internal affairs, although again, I'm super strong supporter of all these bills. But it's a little bit, in my mind, not that I was in the military, but it's like battlefield discipline. They've invested all this resource to get this person to be a police officer, and they really don't want to lose that. So if there's any way they can justify that officer continues on, they will do that. And it's a civilian oversight or a more dispassionate independent would be very different because they just want to get justice and they don't care about that investment. So that's how I think about it. But again, in Spokane, not so much. It's just totally stacked in favor of the existing officer and against any civilian complainant.
Thank you for that. Mr. Bob? You're on mute. There you go.
I'm not sure why that seems to come up that way, but in any event, we did not specifically measure whether discipline outcomes varied by race. So I can't give you a definitive answer to the question, but I can suggest to Manisha that this might be something that you all might like to address.
We'll shoot the question then to Monisha.
That's a good segue. So I worked as a co-chair on Initiative 940, which was the De-escalate Washington initiative, requiring de-escalation training for all law enforcement officers in Washington state. And one of the things we learned working on that initiative is that there was no central repository for data information along these lines. One, there are many agencies that do not collect the information of race of the people that they engage with. And two, we rarely run the data for law enforcement agencies, and we definitely do not run it by race. Now, I say that to say when you ask a basic question like that, you would expect to be able to have the data, you would expect the answers. There is no central repository. There are many agencies that don't collect this information. It's the reason that the bill that Senator Solomon put in, and that's Senate Bill 5259, we actually made the call for you don't know if you're getting what you want if you can't measure it. Like, you get what you measure. And so now we are, and this bill does look to pass this year. But now we are looking to finally require all of our law enforcement agencies to collect and report on a central amount of data in Washington State. The thing that I find overdue on this, let's call it overdue, is that if I were to ask you how many people were killed by law enforcement in Washington State in the last year, the state could not definitively tell us. We only know this data, and when people give you these numbers, we only give you these numbers because we have a group of stakeholders, community groups, who literally comb through media to be able to record these deaths. But law enforcement does not tell us this. They don't report this. So Senate Bill 5259 will be our first opportunity to actually require law enforcement to report this information. And so we hope to have this information going forward. We still don't require during stops people to tell us race. This only can be recorded by an officer's best guess, but we are thinking about ways in order to be able to import that information into the database later. And it's just because our state does not collect that information on the people that they, like race is not listed on your driver's license and those sorts of things. So it's only, you know, you could have somebody who is very clearly white passing, but does not identify as white, and our officers would never capture that.
That's interesting. Thanks.
I,
Senator Solomon.
Thank you. And just add, so I think part of the question, it was, are police officers going to be disciplined at a higher rate if they're officers of color? That is a question / concern that I raised, and I was working with another legislator to bring a data collection into a similar arbitration bill. But we decided to put that one down and go with its more impactful bill. And I think, frankly, forgot to add that piece. So, Monisha, maybe you and I could talk later offline. I do think it's a concern, but we don't have data, and I'm sure we could get data, or maybe attach it to a bill that is more likely to pass sooner.
That would be great. Thank you for that. And then Tony Benengas, do you have a question for our panelists?
I do. First of all, I want to thank the panelists. There's, gosh, so much information. Just listening to you guys, I have more questions than I did before, and it's really an excellent panel. Thank you so much. I was originally going to address this to the senator, but I'd like to hear all the panelists kind of weigh in on this. And, you know, when you talk to the unions, what are their main objections? Or is there something that's in common specifically? Maybe are they worried about privacy? Is it because the labor law says so, they can do all this because it's so vague? Is it they're trying to protect arbitration? You know, what are the key things that they're saying is we can't do this?
Can I address this? I think they're trying to keep their cookies. I mean, I think every interest group in Olympia operates within their own sort of self-defined square of what is in their best interest, defined very parochially, not what is in the interest of the greater good. And it bothers me, but I just think that's a fact how it works out there. So I just think they're trying to protect what they have. I'll leave it at that.
Monisha, do you have a response?
Yeah. So I'll say that I think that I've heard a couple of concerns, one of which is disproportionate power of employers over employees. And so really, particularly in the areas of discipline, there's there's a general distrust of management. And so the discipline that management might hand out and feeling as though they don't necessarily trust their bosses to be to not abuse that power if it's tilted too much in their direction. And so that's where you get a lot of, you know, a chief maybe bringing down discipline and the union saying the chief shouldn't have that much power. And so I've heard concerns in that regard. I've also heard, you know, candidly, there's concerns. There's been a lot of attacks on labor over the past few years, particularly where there's been an encouragement for people to leave labor unions and to kind of opt out and not pay dues. And so I think that there's a concern that if labor isn't perceived at being able to, like, basically guarantee the protection of their jobs, then labor will lose members and they will lose dues and resources. I think that this is one of those cases where we have to also encourage law enforcement has to understand when they keep bad members in their ranks, they actually do a greater disservice to the function overall, right? It makes it harder on those officers who do show up every day to serve their communities when those who should not be in their ranks are allowed to stay in their ranks. So I think it is short-sighted on the part of some of the labor unions to say we have to protect everybody, when the reality of it is they really should just be protecting the ones who are fit for the job.
Thank you. Mr. Bob, response?
I really don't have much to add to what Monisha just said or what the senator said, so I'll just rely on them.
Thank you. I'll ask Mr. Beggs.
Yeah, just quickly, I think the hope is, as labor unions really examine this, now that these bills are coming forward and they're getting pressure from people, including their allies, that they'll take a deeper look and not just have that initial reaction of, oh, this is just part of the narrative of trying to undermine rights of workers. I think that's the first thing. I can tell you, after 5 years of negotiating with our police guild to finally get the civilian oversight ombuds that doesn't really impact discipline, what they kept saying is, we have to imagine the worst day ever. You have a bad mayor, a bad chief, a bad council, and so we have to protect our jobs for people. And so they focus on that. So the way that we worked our way through it on a very local level is we really just got a lot of language and set up a lot of guardrails. And they felt eventually, when we had enough guardrails set up that were consistent with what we wanted all along, but just made it super, super clear, they believed enough that they could do it. They still didn't really want to, but they hadn't had a raise in 5 years. So, you know, we had that went with it. So I think there is room when you get really specific. And the other thing that's lurking out there, I don't think anyone said, but this whole, well, Monisha said it actually really well, of that arbitrators feel sorry for law enforcement, that they might not be able to get future employment. But what she didn't say that I would say is that law enforcement, based on their education and overall value in the economy generally, are not going to replicate the kind of wages they get with the contracts they do in those positions. And so there is kind of a sympathy for that that's disproportionate to what's really going on. And I just think we need to call that out and say, yeah, that may be true, but you have the power to take people's lives and their liberty. And so we're going to have a special rule, and it's not going to impact all these other workers. And I just think we need to make it, we can't just say it's not going to impact other public employees. We have to explain it and show it.
Thank you. Kim Ambrose, do you have, oh, she's not on anymore. Okay. Then is Brian on? Brian's not on. Oh, okay. So we still have 10 more minutes then for questions from our committee members. Do our committee members have any more questions for the panelists before we open it up to public comment?
If I could just interject, I think Brian's, at least there's an entry on the screen there, but I don't know if he's
Right.
actually with us.
He had informed me that he
Okay.
had to step away, so I'm not sure if he's back yet. But I see Eric's hand up, and then you can just indicate through the raise your hand button. So Eric, would you like to ask a question?
My understanding is that under some circumstances, if there's been a disciplinary decision by a police department, there's a state board that reviews it. I think if the force involved isn't unionized, maybe PERC, I'm not sure. I'm wondering whether one solution to the arbitration problem would be to provide that in the case of discipline based on use of force, the review wouldn't be by an arbitrator, which is subject to the conflict of interest problems you mentioned, but would go to a permanent board where the members wouldn't have a stake in getting getting more money if they rule from one side or another. That already exists, as I understand it, for non-unionized officers. I'm wondering whether it would make some sense for use of force to send that subset there, so there's still review, but by somebody else, somebody who does it anyway. Does that make any sense?
So some of the bills that we've been moving this year will address some of this. So the Criminal Justice Training Commission, the bill that we talked about, the decertification bill 5051, those cases will be reviewed by that criminal justice, a smaller Criminal Justice Training Commission board. And so that was part of what's set up in the bill. And it is, Senator Solomon was right. I gave you a very simplified version of that bill. It's actually about 40 pages long. It's one of the longest bills I've ever read, but it's really meaty and it's really important. And so it does set up that commission with the Criminal Justice Training Commission. I will add, and I apologize for being so wonky today, House Bill 1267, which is a bill that would create an Office of Independent Investigations, and that would be an independent investigation of lethal use of force cases by all law enforcement officers. It will just pertain to law enforcement, and it would take the investigations for lethal use of force. It doesn't mean somebody has to have died necessarily, but that the force used was lethal and likely resulted in serious injury. The only exception to that is we also consider sexual assault by officers, particularly on duty, as a very strong use of force. And so sexual assaults would also be investigated by the Department of Independent Investigations. And that's because we've just found that in leaving it up to law enforcement to investigate themselves, to investigate their peers, that there have been a number of shortcomings, and I know I'm being understated in that, but there have been a significant number of shortcomings, and so we're pulling that function out into a centralized statewide body that will be unbiased and not have direct peer relationships with the folks that they are investigating.
That's really helpful. Other committee members, do you have questions for the panelists? I don't see any hands. And Brooke, I don't see any members of the public. So
yeah, we no longer have any members of the public.
Okay. So then we will move to adjourn the meeting, and I have a few sort of follow-up points to make. Definitely want to thank the panelists for joining us today. We know that you're all extremely busy. You get probably a lot of requests to engage with different groups, and we appreciate you choosing us this morning to spend your morning with us. So thank you for that. The transcript and other materials will be available within 30 days following today's meeting. If you provided your email address when you joined, we will send you follow-up information regarding how to access those materials. We will also notify you when the committee is meeting for follow-up discussion and when the report will be available. The record will remain open through April 19th, 2021. So if anyone would like to submit written comment, please send this by email to Brooke Peery at bpeery@usccr.gov. And with that, I'd like to call the meeting to close and adjourn. And committee members, I'll see you at 1. Senator Solomon, yes, please.
Yeah, sorry, I was looking at a bill. I wanted to respond to the last question. Sorry, I can't quite remember the last question, but there was a bill that I was working on that took a very small effect of discipline issues, such as a pattern of the illegal use of force, or that violated employer policy, or a use of force that violated employer policy that created serious bodily harm or death, and in discipline imposed for that, as well as illegal acts, theft, things like that, and material dishonesty. The arbitrator lost the ability to overturn the discipline under this bill that was imposed if there was a finding that it was based on a factual scenario, right? If it, and so that bill I was working on with the Washington Association of Police and Sheriffs, that bill got sidetracked. I put that down for the bigger ACLU 514 bill, but it still exists. I haven't introduced it, but that's another way to approach it. So I don't know. If there's any thoughts later on that somebody wants to share about that approach, we can talk about it.
Great, thank you for that. We have a lot of bills to look up and understand and digest. So
there's really more than what we talked about.
Yeah, definitely. Well, we appreciate everyone's insight and knowledge and you sharing it with us. And we look forward to engaging with you in the future, and definitely we'll send you our final report probably this summer or early summer. So thank you, everyone. Have a great afternoon, and I'll see the committee at 1 o'clock. Take care.
Thank you.
Bye.